And I'm very, very pleased to say that with me today is the one and only Tavis Williamson, Esquire, better known as Walter. Hi, Walter. How's it going?
I'm doing good, doing good. How are you?
Smoky. Smoking. My
All right,
feet are smoking.
Smokey.
I've done about 17,000 steps with this dog of mine already.
Yeah, I've got two that keep me on my toes.
Yeah, yeah, yeah. So we're looking forward to it's quite an early kickoff as far as Sunday, because I think we're at 11 o'clock. And I really want you to act as not so much co-host, but main host with me sort of in the background. So I'm going to let you introduce. Oh, there we go.
Yeah, little. He's funny. He's the only dog I've ever had. Looks at the TV and he sees a dog and he barks.
Yeah.
Every other dog I've owned can't see. He goes crazy. I don't know what he'll do if he sees himself, but he's really a good guy.
Yeah.
Okay, go behave, buddy.
He's a cutie.
Yeah, so I'm really excited. We got, a good friend coming on, Vic Fizell, a fellow Central Texas lawyer.
Mhm.
Very, very famous what he went through, and it'll be really enjoyable having a nice chat with him and you, and talk about what he went through. And of course, he knows a lot about the criminal justice system from both sides.
Yeah.
He's a fantastic trial lawyer. He's rated one of the top 100 trial attorneys in the country through an organization, and just has a really, really interesting background, how he grew up. Very, very young man, was elected, 31,
Yeah.
was elected to be DA, so probably 5 years out of law school. Went to Baylor Law, excellent law school, and just a really, really
Mhm.
nice guy. And it's just interesting, not only his fantastic knowledge about the criminal justice system, but also as a prosecutor, as representing people who are usually the little guy. It's what he's been doing for 20, 30 years now. But he's also a philosopher. I mean, he's like a Renaissance man. He can play music. He's just written a great book we can talk about.
Sure.
But some of his major life philosophies have evolved and changed 180 degrees as
Sure.
he's gotten older. And so maybe we can talk about some of those things too. But it'll be a good time.
Yeah, yeah. I mean, just to say, obviously, Vic Purcell was the one of the stars, along with Henry Lee Lucas, of the Confession Killer, which for those of you that have watched it, I would highly recommend going and watching it again, because you'll get a good insight of what Tavis is going to be chatting with Vic about. But while I've got you here, Trav, two things I wanted to ask you. First of all, the latest motion by Kathleen Zellner and the state's response. Thoughts on it?
Again, under the Wisconsin system, you can't bring successive motions. You have to, despite what the state says in their opposition. And it's pretty much this way in every state. They want you to file everything in one post-conviction motion. Mm-hmm. They don't want you to split issues. And so, you have to bring everything in there. So this is nothing new. She filed a motion to remand regarding the computer evidence. She filed a motion for remand and stay regarding the rapid DNA testing in December of 18, right when a brief was going to be due. That got denied. They extended the time for her to file a brief for a few weeks, and then she became aware that some of the bones had been returned to the family. She filed another motion to remand and stay. The state filed this motion response that said, "Oh, you can either dismiss your appeal, the one had been waiting for forever, or you can just, forego that issue. And the judge was a little bit miffed with the state's response, pointed it out that it was, silly and absurd and not the type of thing that should be in a legal pleading, and not in a pleading relating to something so serious. But yet again, you kind of see that in some of the response. So she is somehow made aware of this witness, and it's people are focusing on, understandably, the sleuthers are focusing on, well, his story, this particular person pushing the vehicle, that it was the RAV4 with another gentleman that had a beard about 6 feet tall. They're focusing on that, but that's really not the important part of it. What the important part of it, and what we hope this person's credibility really comes into play, is that he saw something and he reported it, and that there's somehow a record of it being reported. And or given that things have been put in safes for safekeeping or so on and so forth, the fact that there is no record of it may not be surprising at all.
Yeah.
And so really the key is that it justifies a brief hearing.
Yeah.
And so it's what he says he saw, and which person, what person, that part's not important. It's the Brady stuff that's important.
Yes.
Was it information that would be helpful to the defense, that exculpatory material? And Buting has already tweeted why this would obviously be Brady. It would have gotten us the Denny third-party suspect, period, end of story. And you don't have to show it would change the outcome of the case, and you don't have to show an ill motive anymore in Wisconsin. All you need to show is that it would have been a benefit. And so if she did get an evidentiary hearing on it, I'm sure Buting and or Strang would testify that, if we'd had this information, we would have followed up on it. It would have made a huge difference in the case. I don't think anyone would dispute that. And so hopefully, the investigators went down. You can tell right from the affidavit that Kirby and Kirby were involved in getting the affidavit. And, not every witness is perfect, and you get what you can get. And but you have to deal the cards that you have. You can't, we saw what happened with her when they were doing some initial testing, and then they met to plan more testing on the RAV. And they're in the middle of that, and Kathleen says to the other side, hey, should we let the judge know, we're doing this? And so, oh no, we'll let her know next week when, we have this other stuff, we're good. So let's check our calendars and we'll get back, we'll figure out what days are good for both of us to have the evidentiary hearing, and so on and so forth. And then next thing you know, the circuit court judge issues the order denying the motion for post-conviction relief. She says, wait a minute, we were doing this. And she said, well, you should have told me. And it didn't matter. And, it got appealed. But so she has to file it.
Yes.
It's credible. So we had that jailhouse person that was apparently interviewed for another documentary that's never been released yet. But was apparently talking to somebody in prison, and they did this whole confession that they're the real murderer. And that was turned over, I believe, to the prosecutor by that producer and Kathleen. And Kathleen went through it and said, this is all, we knew about this, and it's just all ridiculous. I know for a fact, because of certain things, that what he's saying is not true. We don't have that situation with the affidavit in the motion here. Now, people said, well, she should check this and corroborate it. The state said there's no corroboration. Well, how do you corroborate it? How do you vet it? You're in post-conviction on appeal. You have no subpoena power. You can't subpoena the newspaper company to find out. They're usually not employees; they're independent contractors. But there would be payments. His employment or contractor records. You can't go out and subpoena that stuff. The newspaper couldn't even give that to her, even if they wanted to. It's, personal records. Just how can you vet all of that stuff? Because again, what's important is, could he have been there at that time? He may have been completely wrong about what the car was or who he saw, but that's really not the question at this stage. The question is, did at the time he believe he saw what he saw, that he reported it, was told, thanks, we already got the guy, and that was never passed along to Strang and Beauty. That's all that's really important. So the response was kind of what I expected. That a lot of, it's Stephen delaying this. When you keep CDs in a safe, when you violate preservation statutes, or when you arguably could be a violation of the preservation statute, prudence dictates that you call up and say, hey, we don't think the statute covers this, but we're giving you notice anyway. If you have an objection, let us know. They just went ahead and released it. And one of the people involved in releasing those bones was involved in the drafting and passage of that legislation. It's just a total lapse in judgment. But the court ultimately said, no, this is worth, we want this issue to be part of everything. We don't want it to come up to us rule, go through all of this effort, because if they do remand it for one or more issues, it needs, you don't want this other issue hanging out there about this eyewitness account. But and so they go through all of that and then come back and start over on the eyewitness account. That is not judicial economy. And it was surprising that the state said, that these were really delay tactics that Kathleen was using and really weren't judicial economy. I mean, it's just nonsense. It's why, successive motions are prohibited, and they want it, to the extent you can, all in one motion. And so she did it quickly. I'm sure, because again, they could rule any day that they could rule on the appeal, and she didn't want to take a chance. So now that, the appellate court may say, look, we understand you're doing this because, you don't want to waive anything, and you wanted to show that you were moving on it immediately. And we're going to go ahead and pull this issue out.
Mhm.
We're going to put it on hold. You're protected by what we, but we're going to deal with it later. They have that option. They can say, no, let's get this all done.
Mhm.
It's really interesting. The state keeps saying, oh, it's delayed, it's delayed, it's delayed. Delay doesn't hurt the state.
Ah,
Yeah.
yeah.
Stephen's the one sitting in jail. They'd have to address the issue. They might have to appear at a hearing, so on and so forth. I hope if they do grant it, they don't use that wishy-washy language they did the 2 times before and say the court shall conduct, and then they put the word any hearings it feels are necessary to resolve the issues. And then that gave the circuit court judge an out, and she just said, hearing's not necessary. I can rule on this from here. There's nothing to look at here. Well, this time I hope, if they're inclined to grant the motion to stay and send it for an evidentiary hearing, I hope they order specifically the circuit court shall conduct an evidentiary hearing to include these issues, and then make findings and fact, conclusions of law, and get back to us by a certain date, and not give her any wiggle room.
Yeah, that would be great.
Or assign it to a different judge that, it's apparent to us, whatever. Be better if it went to a different judge. So hopefully that'll happen. And then, of course, they could just outright deny it. And hopefully that's not the case. But, she's not filing it as if I've checked this all out. I know it's 100% true, and I've figured out the case. She's filing it because she has to.
Yeah.
And she wants an evidentiary hearing because she doesn't know. And you don't have any other mechanism. You don't have any other means of checking it out, verifying it, vetting it, so on and so forth. It's one of those things. Got to get the person on the stand, tell their story, let the other side cross-examine, and then subpoena documents to the hearing. In their response, the state said she should have done an open records request to the police department. Well, the police department's been taking a position, depending on who makes the request, of they don't need to produce them because it's pending litigation. That's one of the exceptions. That takes time, 2, 3, 4 weeks. There's time limits under the open records law in Wisconsin, but it wasn't going to be coming within a matter of a day or two while she's waiting for those records. And I believe trial counsel specifically requested all phone calls and communications from any tips or whatnot, that those should have been produced to Jerry and Dean. And then if he said that to them, that's Brady. And Brady, the duties under Brady exist pre-trial. That's when they're most useful. During trial and after trial. So they have a duty to go in and dig for that stuff. And if it's there to produce it. So and I'm surprised they put that in the brief. I think that if Kathleen decides to file a reply to their response, that she'll, if it were me, I'd say this is exactly the type of mentality, the thinking, the culture win at all cost in this Attorney General appellate office that they should know better, especially in light of the recent case on Brady that came out of Wisconsin, where they eliminated an ill will motive of the trial prosecutor. You know, they said that's no longer a requirement in Wisconsin. We're getting rid of that. This ill will or you know, ill motive. And you know, the response I would be filing, and she may file as well, would be that the duty's on them to dig for it. You don't need an open records request. They're aware of this now. They should be rifling through everything and determining. I was surprised they didn't attach an affidavit saying we've gone through all of the records and haven't found anything, or you know, this never happened. And maybe because they can't. Maybe they've gone through it and they've said, well, what's the story here? Well, there may be something. Okay, well, we better not file an affidavit. Or, well, we erased all that stuff. Or, you know, who knows? But that's, I don't know. It's something in the case. I know a lot of people are disappointed. It's might drag it out, but the time frame on the rapid DNA test, that's the one that court denied. That was all done and over with in less than 2 weeks. The one that they granted, the court granted it within 30 days. And then, you know, it took another 2-3 months to get everything sorted out. And the circuit court judge issued an opinion that they were denying it. And then, but then she could add that issue to her appeal. And so, you know, that it did delay things ultimately by the time she filed her brief. But I, you know, could go on and on. The last thing I'll finish with is that, but this appeal has been languishing for 4 years. You know, at least 2 of those things is because the state's attorneys, either below at the trial level or appellate, didn't turn over things that they should have, resulting in the delay. Again, who does that hurt? Doesn't hurt them.
No.
Hurts Stephen. He's the one languishing. And but you know, what's been going on in the United States and our court system for the last 12 months? I mean, it just really silly stuff. Wasn't very impressed by their response. That's my thoughts on it.
Finally, well, thank you very much for that, because you know, it's always great to get your insight. Any abiding memories of the dude you'd like to share with us?
Oh boy, you know, it's always tough to go back to that, but you know, but actually I do, because I was really involved with the dude on the motion, you know, about the return of the bones. And you know, December of 2018, and doing a few videos with him about these motions to remand and the opposition. And you know, Richard could be, I mean, he was 110% on the case, but his delivery, it would depend. So you remember, you know, he'd get red in the face about certain things, and just, and some things would just, that the state said. And then, you know, while I was reading the opposition, the response of the state. Have you had a chance to read it thoroughly?
The state response.
Yes.
I got so far down and thought, no, this is just garbage.
Okay. Well, spoiler alert. So I'm reading, and then all of a sudden, here's that word, disingenuously.
Yes.
I just smiled. I remember the first time when he was reading some motion, and I just met him on YouTube a few nights earlier. It was relatively soon that after we had started chatting offline and whatnot. And then I typed in the chat, or maybe I may have been on live with them, and I said, disingenuous is code word for a lawyer saying, the other side is full of shit. You're, and I said, in Texas, you better be careful, because we understand, you're basically the other attorney is calling you a liar. And we in Texas, we'll need to ask Vic about this.
Yeah.
You really need to be careful in Texas before you throw out the word disingenuous.
Wow.
But you remember how that word,
yes.
There's a few different words that got caught up in that were a running theme. And I don't know if I would say I was the start of that, but it certainly brought it to a new level. And in many videos after that, Richard would be talking about disingenuous.
Yes.
And he added it to his lexicon, and I mean, and so the D word would be, started popping up with. I know you have a couple of words with him like that also. I can't remember what they were, but so I got a big smile when whatever page of their brief disingenuously came up.
Yeah.
Maybe they threw that in there in his honor. Who knows?
Probably. Yeah. I mean, I just remember that the fact that for quite a long time, he was the dude, and he was calling me Donnie. And it was great when you came along, because you were Walter, and you referred to me as Smokey. Smokey's a lot better than being Donnie.
Yeah, I switched it because I watch that movie 3-4 times a year, and started looking at it, and I'm going, well, Smokey in real life is a very accomplished musician, super accomplished, from Austin, and he was a guy that insisted on following the rules. When he didn't agree with Walter on the call, he appealed it through the proper process. And I'm like, Donnie's a great guy, but Donnie was ill-informed. He was out of sync. And I'm like, Paul's not ill-informed, and he's not out of sync. We need a different character. So I went with the musician, Smokey.
Excellent. Well,
I remember your wife, one time we were doing, and I heard Eunice off camera say, Smokey. She said, I thought you were Donnie. And you said, no, Tavis changed it. I don't know if you remember that. So Tavis changed it. I'm Smokey now.
Yeah, thank God for that. Anyway, Trav, I really appreciate you taking time out to have a chat with us and your expert insight. Really looking forward to Sunday at 11 o'clock. That's Central Time. I think that's an hour later. Is that midday for you? No, you're Central Time as well.
Yeah.
That's perfect. I think,
and I'm definitely the same time as Vic.
Yes.
And but it'll be good catching up with him again, and going to let him do all the talking because he's just a really, really interesting person, very knowledgeable, and I think people will really enjoy his insights. And hopefully we'll have some folks watching the chat because I know there will be some great questions for him.
Yeah. Excellent. Well, thank you very much, and we'll see you soon. Bye for now.
Bye for now. It's bye from him. It's bye from me.
Bye from me. Bye for now.